5 seconds to go. Start. Apart from the above civil suit bearing OS number 293 of 2012, the plaintiff respondent number 1 filed another civil suit for prohibitory injunction, which was registered as OS number 238 of 2012. Stop. Both these civil suits, being OS number 293 of 2012 and OS number 238 of 2012, were decided together by the trial court in its common judgment dated 28th January 2014. Stop. After examining the evidence on record, the trial court rejected the case of the plaintiff respondent number 1 with the findings, inter alia, that the circumstances placed on record did not probabilize the case that by defrauding her, the husbands of her sisters got executed the sale document Exhibit A1 while making her believe that it were a security document for getting new films. Stop. The trial court also found that no steps were taken by the plaintiff respondent number 1 to examine the sub-registrar who had registered the sale deed, whereupon she had put her signatures on, being allegedly made to believe it to be a security document, and she failed to discharge the burden of proof in terms of section 103 of the Indian Evidence Act, 1872. Stop. Without much elaboration, we may take note of the relevant findings of the trial court as under, para. So, the aforesaid circumstance never probabilized the case advanced on part of plaintiff that by defrauding her, the husbands of D3 and D5 succeeded to execute Exhibit A1 by making her believe that it was a security document for getting new films from a distributor as claimed. Stop. Para. Though plaintiff is having the case that Exhibit A1 is the result of fraud, undue influence and coercion, etc., exerted upon her by the persons whom she was having confidence, no steps has been taken on the part of the plaintiff to examine the registrar who registered Exhibit A1 sale deed, wherein plaintiff has put her signature, being it as a security document for getting new films, as made believe on the par to D3 and D5, though burden of proof is upon her as per section 103 of the Indian Evidence Act. Stop. So, from the available evidence, in my opinion, the Exhibit A1 sale deed cannot be set aside since it was voluntarily executed by the plaintiff in favor of D1. Stop. Hence, I find these issues against the plaintiff. Stop. Para. In view of the above, the trial court proceeded to dismiss both the civil suits, being OS number 293 of 2012 and OS number 238 of 2012, while leaving the parties to bear their own cause. Stop. Para. There had been two other civil suits, being OS number 181 of 2007 and OS number 497 of 2006, which were filed by the respondent numbers 2 to 5 of the present appeal, sisters of the respondent number 1, seeking partition respectively of theatre and land on one hand and shopping complex on the other. Stop. These civil suits for partition, as filed by the four sisters of respondent number 1, were decreed by the trial court. Stop.